Hey, welcome to today's video. I'm Richard Chapo. I'm an internet lawyer in San Diego, California. Today we're talking about in-house counsel's role for CCPA compliance, the California Consumer Privacy Act. And so, of course, the CCPA is a new California privacy law. It goes into effect January 1st, 2020. Certainly for security measures, it's going to go into practical effect a little bit later as far as enforcement actions brought by the California Attorney General. That's something we can talk about a little later. But regardless, the CCPA represents somewhat of a revolution in privacy law in the United States when we're looking at the business to consumer relationship. And it's been compared to the GDPR, the European regulation. It's kind of a lazy comparison, to be quite honest. The GDPR is based upon businesses having a legal basis for the collection of personal information from individuals. And, there are various legal bases that are allowed. One of the more common ones, of course, is consent. But the CCPA doesn't have any of those requirements. There is no requirement to get consent unless a particular age issue comes up. But generally, you don't need a legal basis. You don't need consent or anything of that sort. However, there are quite a few other rights that are granted under the CCPA, and there's quite a few steps that you have to take in regards to compliance in relation to data collection and what have you. And so it is a complex law. We don't have anything like this in the United States. And so perhaps the first role of in-house counsel is to make sure that management and the key employees in the company understand this is a major change. The days of, for instance, slapping up a simple privacy policy on a website or an app, or giving a simple privacy notice to your consumer or your employees, well, those days are over. Now, certainly only if you have to comply with the CCPA, there are certain tests and thresholds. But we're talking about a situation where we're moving to a much more interactive relationship between businesses and consumers in regard to the personal data of those individuals. And in that sense, it is similar to the GDPR. Consumers have more rights. They can exercise rights such as rights of deletion. They can request what information they have that the business has for each of them. And unique in the CCPA, you can submit actually a request to businesses to not sell your personal information as a consumer. So if I have an account with Facebook, starting January 1st, 2020, I will be able to submit a notice to Facebook telling them to not sell my information to third parties. And you can imagine the implications of that. Now, as in-house counsel, if you are going to try to ride the CCPA like a mad bull, it's really important to understand that the CCPA is somewhat unique and flawed because it was not introduced to the California legislature as a bill. It was introduced as an initiative under the initiative system in California, where they were trying to essentially get it directly onto the ballot. It would have bypassed the legislature and so on and so forth. So it's drafted poorly and in odd ways. There have been a number of amendments since it was enacted in 2018. So it's important to make sure you're looking at the latest amendments. Senate Bill 1121 was enacted in late 2018. That's kind of the crowning document, but there have been amendments since then. So you want to make sure you're looking at the correct ones. Now, the big thing with the CCPA is because it was drafted as an initiative, a lot of the actual qualifying language can be found not so much in the body of the document as it can be in the definitions. And there are actually compliance steps that appear in the definitions. So if you don't read the definitions closely, you're going to be in violation of the CCPA. So the definitions can be found at Civil Code Section 1798.140. And I would encourage you to go read those definitions because it's going to give you a real feel for the scope of the law and what you're looking at here. Let me give you just an example, possibly. Let me see here. How about the definition for personal information? So if we think about personal information, what comes to mind? Name of the person, email address, maybe the street address, phone number, things of this sort. Well, the personal information phrase is defined very, very broadly under the CCPA. And it actually reads as follows. Personal information means information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. Personal information includes, but is not limited to, the following if it identifies, relates to, describes, is capable of being associated with, or could be reasonably linked directly or indirectly with a particular consumer or household. Identifiers such as real name, alias, postal address, unique personal identifier. So if your company is giving somebody an identifier, online identifier, IP addresses, email address, account name, social security number, driver's license number, passport number, or other similar identifiers. And then we get into some of the more expansive elements of the definition. So subsection, let's say D, commercial information, including records of personal property, products or services purchased, obtained, or considered, or other purchasing or consumer histories or tendencies. So if your company is maintaining data on what people are looking at or purchasing, which is common in larger retail companies, that counts as personal information. Subsection E, biometric information. So if you're using biometric information for passwords, biometric information, particularly as it applies to employees. Now, the CCPA, as I'm recording this, there's some amendments up as to whether it'll apply to employees, and if so, to what extent. So this is kind of a fuzzy area. But you can also have biometric information with customers or with visitors. Facial recognition technology, for instance, would fall under this. So again, we're looking at some very broad scope here. Subsection F, personal information includes internet or other electronic network activity information, including but not limited to browsing history, search history, and information regarding a consumer's interaction with a website, application, or advertisement. So that subsection is so broad that it basically means any information that you're collecting online. It literally is that broad. And if you understand how servers work, well, when somebody somebody does a search, let's say on Google for some subject, they see a listing for a page on your company's website. They click that page. When they do that, the browser is going to send a signal to your server. And then that signal, there's going to be identifying information. There just is. And arguably, that would fall under subsection F here and would be counted as personal information. So if subsequently a consumer does a request for what personal information you have about them, are you going to have to produce that information, the server information? Sort of sounds like it. G, subsection G, geolocation data. Subsection 8, audio, electronic, visual, thermal, olfactory, or similar information. You can see how broadly this is going. I mean, if we talk about audio, somebody who comes in and speaks to your employees at lunch, if they're a California resident, well, isn't that audio data? So the definitions, as you can see, they start getting very, very broad, and they mean, or they're defined often in ways that one wouldn't reasonably anticipate based on the phrase being used. So you want to read through the definitions. It will make your life much easier in the sense that you'll have a better understanding of how broad the CCPA reaches. So the definitions, and then data. You have to know your data. Unfortunately. Now, the GDPR, of course, requires certain record-keeping requirements, and it requires you to essentially go ahead and create a data chart, a data flow chart, so you know where you're collecting data from, where it's going through the business, who it's going out to, and so you have these records, and you can basically get a fix on your data practices. The CCPA does not require that. There is nothing in the CCPA requires that. However, you're going to want to do it. You're going to want to do it voluntarily because, again, if a consumer under the CCPA makes a request for their, they want copies of their data, well, you're going to have to produce all that data. If you don't have data flow charts, how are you going to know where it is? So you want to take those steps. It's going to be very important. Depending on the nature of your company, the IT, are you using third-party services for your IT? There are all kinds of issues that are going to have to be flushed through, and you can see how this is starting to get very complicated. To this extent, you want to get a grasp of your systems. We live in a third-party system environment and a module environment, and you may well be using software, for instance, that tracks individuals that you may not be aware of. So for instance, let's use a simple example. Say a lot of websites are built on WordPress. Well, WordPress plugins will often track visitors to the site, and most people don't realize that. And so at that point, if they're tracking visitors and they're identifying them in one way or another, well, arguably that's personal data. So you're going to have to look at that. You're going to have to look at vendor contracts, to try to glean all this information. And again, it starts getting more and more complicated. Three, set internal policies. So internal policies are going to be set on technical compliance requirements. They're also going to have to be set on practical aspects. So let's talk about technical real quick, just to give you an idea. This is pretty basic, but it just needs to be organized. I'm a consumer. I come to your business and I say, I purchased a couch from you 2 years ago. I'd like to know what personal data you have on me. Okay, well, what happens? Who in your company is responsible for taking and processing that request? What are the procedures for processing that request? How is data identified? What are the policies on production? You're going to have a time limit of 45 days where you have to produce that information. Is there a specific timeline of compliance? Who is the person overall that's in charge of that? Where does the buck stop? And so on and so forth. And then you're going to want to do practice runs, because you sure as heck don't want to be trying this out for the first time you get a request. It's just one of those things. Now, what about practical policies? Well, practical policies come into the management level, and these aren't necessarily technical legal requirements. It's just common sense issues you need to think about and you need to speak with management about. So, for example, let's start with the definition. Let's go back to definitions. So the CCPA applies to consumers. And under the CCPA, consumers are defined as natural persons who reside in California. So we're essentially talking about California residents. Okay, well, let's say you're an e-commerce store, or let's say that you have a website or an app that's very prominent in your business. Okay, on that privacy policy, or if you can create a separate California privacy notice, people are going to be able to go on there and read that they can exercise these rights, that they can ask your company to produce information, the information the company has about that person, to delete certain information, all these different steps. Okay. Are you going to offer those rights only to California residents? Or are you going to voluntarily offer those rights to anyone who makes a request? Now, the technical legal answer is pretty obvious. If somebody is living in New York and they make a request under the CCPA, the company does not need to comply because that person doesn't fall within the definition of consumer. However, what is the likelihood that that person reacts negatively to your response? Might they go on social media and start saying negative things about the company? Maybe go to Yelp, leave a negative review. These kinds of things. There's this negative PR implication that needs to be thought through. And you see this with a lot of websites, for instance, online, where you'll see cookie pop-ups if you're located in the US. And the interesting thing about that is the GDPR only applies to individuals who reside in the EU, or actually they don't even have to reside there. They're just located there at the time. So why are you seeing cookie pop-ups from a company that has a website based in the US if you're sitting in California or in some state of the US? You're not in the EU. And there's two reasons. One, some of them have IT departments that are too stupid to program the cookie warning correctly. But the other reason is a lot of companies have just said, you know what? If we just comply with the GDPR, we're going to have to give these rights to everybody. And they've just made that practical policy decision. And, that can be a good decision. It can be a negative decision. It just sort of depends on your personal views. If you have a business to business type of company that is providing industrial machinery to your client base, it's probably not a big deal just to limit it to California. It's not like, most of your clients are going to be on Yelp or social media. But if you have a store selling products online and you're doing big business online, well, at that point, then you need to be much more concerned about how your target audience may react to being told that they don't have the rights that people in California have. And in that situation, you may want to have a more expansive policy in regards to providing these rights to everybody. So these kinds of things need to be thought about, and that's going to be critical with in-house counsel to raise those issues with management. And obviously, you can bring in external counsel to do it. In-house versus external counsel comes down to your company, how complex your data requirements are. It also comes down to how comfortable you are with privacy law. If you suffered through GDPR compliance, you probably have a pretty good idea of what's involved in these cases. If not, and this is brand new to you, external counsel is the way to go. whether it's me or somebody else, you're going to want to make sure that you have somebody that understands this law. Trying to learn it from scratch and learn privacy law from scratch can be quite difficult because not only is the law changing quickly, but there are areas that are fairly vague. And so you need to understand some of the pre-existing case law that we've seen around the world that these laws are being modeled after. And so it's going to be interesting, to see how all this plays out moving forward. As in-house counsel, you may want to take on that burden of staying up to date, or you may not. In-house counsel tends to have quite a few different things going on. So it'll really just depend on, personally how you handle your role. But there is certainly a scenario where you definitely want to use external counsel. So anyways, that's it for today's videos. If you have any questions or comments, feel free to contact me at SoCalInternetLawyer.com. If you have any comments, you can post them below on YouTube. However, keep in mind that that is a public forum. If you're interested in learning more about the CCPA, you can head over to our page on YouTube. We have a playlist that's actually devoted to the CCPA with a wide variety of CCPA videos. And so you should be able to find answers there to any questions you might have. If you enjoyed the video, consider give me a thumbs up. If not, thumbs down. And thanks for watching.